Remember that story we did a couple of weeks ago about a federal court saying that bulk phone surveillance was unauthorized? This was really a big deal, but we weren't exactly sure at the time what the reaction would be from the Obama administration, how seriously that determination would be taken, whether there would be any repercussions not to following the decision by that court. We now have at least some of the answers to these questions. The Obama administration has asked a secret surveillance court to ignore the public court's decision. As The Guardian writes, the legal request filed nearly 4 hours after Barack Obama vowed to sign a new law banning precisely the bulk collection he asks the secret court to approve, also suggests that the administration may not necessarily comply with any potential court order demanding that the collection stop. So, as far as The Guardian is concerned, on the one hand, President Obama's attorneys doing the exact opposite of what President Obama was doing publicly, and all of this sort of encapsulated and interpreted as a whole suggests that it doesn't matter what that public court says. Obama's lawyers have already gone to those secret FISA courts to say, yeah, we're kind of looking to just continue doing this and not really worry about what that public court said. And last week, U.S. officials did confirm that they would ask the Foreign Intelligence Surveillance Court, FISA, to turn the domestic bulk collection spigot back on. Not really surprising to me, Lewis, but interesting that it was done in such a way that it was not kept totally private and secret.
Maybe it was supposed to be. Did we really think this was going to happen? No, like you said, not a surprise. It's just it's too good to let go, and I did not think that the administration would allow that to happen.
No question about it. And as we now have heard from Justice Department National Security Chief John A. Carlin, that he asked the FISA court to set aside the declaration by the Second Circuit Court of Appeals, which was decided on May 7th. The appeals court ruled that the government had erroneously interpreted the Patriot Act's authorization of data collection as relevant to an ongoing investigation to permit bulk collection. And this is, it's more the same. I mean, I can't say that this is very surprising. And we have these secret courts making rulings that affect the entire country in direct contradiction, at least in this particular case, to what public courts have said. And most people will never hear about it. Too few people, Lewis, will even hear about the court's public decision that we talked about. But even fewer will ever find out that the Obama administration was simultaneously asking the FISA court to ignore the public court's determination. And, at some point, I just have no silver lining that I can find. This has just become sort of the status quo, one of those areas on which Republicans and Democrats, by and large, operate in the same way.
I guess the silver lining is that, in theory, this could prevent some type of terrorist attack, and this could save many lives. That is all we really have, but we have no evidence that that has happened yet.
That's nice. That's very quaint, Lewis's idea there. If nothing else, this will maybe keep us safe. I mean, I would love to actually think that, and we've talked about how differently people might feel about the TSA security theater if we had evidence that it was keeping us safe. We found out something like 95% of test banned items got through TSA security. And of course, that claim made by NSA officials that all sorts of attacks had been prevented by the bulk surveillance. And upon just the most minute scrutiny, we found out, well, it actually, we don't actually have any specific examples whatsoever that happened, but a very nice, quaint hypothetical, Lewis, that you're pointing out there. I like it.
Well, you can't deny that there is a remote possibility that it could prevent some type of attack. And so that's what they tell us is the whole point of this system.